I should say at the outset that FDI remains crucial for the development of the least developed countries. In the past 20 years, FDI flows to LDCs increased enormously, from around 5 billion in US dollars in 2000 to 40 billion in 2015. 2015 actually marked the high water point of FDI in LDCs. In 2016, FDI flows to LDCs have declined slightly. And of course, we can understand the reasons for such a dip. LDCs and FDI flows to LDCs depend a lot on the price of natural resources, which fluctuate in line with market pressures. So once the price of these resources starts to climb again, and we hope it will happen soon, it is to be expected that FDI flows will pick up and push levels past those that were attained in 2015. The fluctuation of market prices of natural resources is not, however, as you all know, the only challenge facing LDCs with regard to FDI flows. There are many others. I will briefly address today the challenges that LDCs must confront in relation to the negotiation of investment agreements, the conclusion of such agreements, and in the settlement of disputes that may arise from such investments and investment agreements. Let me start with the first set, because I would like to address two sets of challenges in view of the time available. Let me start with the first set of challenges, which may arise in relation to the negotiation and conclusion of BITs, bilateral investment treaties. I will refer to them by the acronym BIT. There are 3,300 of them which have been concluded all over the world. 621 of such BITs have been concluded and signed by LDCs. That's about 20% of the overall number of BITs concluded worldwide. BITs set out, as you all know, the reciprocal obligations of the parties and establish the mechanisms by which disputes related to investments are to be solved, normally outside the host state's court system and by arbitral tribunals. This is something that most LDCs, when they are signing BITs, are apparently not very much aware of, because I have had many instances in which LDC countries that had to appear before arbitral tribunals said, we never consented to appear before arbitral tribunals, but actually they did. And that is my second point. My second point is the standards and the terms that are included in the BITs. The LDCs started from a position of disadvantage because the capital exporting countries come to the table with a model BIT, ready-made BIT. the LDCs don't have ready-made BITs. They don't have medal BITs. They have not developed such instruments. So they have to read and comment on what has been given to them. And of course, that puts you at a disadvantage when you are negotiating with people with the people who have prepared such model BITs, because each time you ask a question, they will give you 100 explanations and lecture you on what these standards mean. And that is the first disadvantage. Of course, LDCs are not the only ones who suffer from such a disadvantage. But it is something that they can overcome, and I will come to that. But I simply want to point out that in the 1970s, 1980s, 1990s, the situation was actually much worse than it is today. Because in a recent study on BITs and how they are concluded by developing countries, not only by the LDCs, but by all developing countries, the author interviewed many of the negotiators from the developed capital exporting countries. And actually, they told him, well, and this concerned, one of these comments concerned my own country, Somalia. A negotiator from a European country in 1981 signed a BIT with Somalia, and then he commented to the author of this study, I don't think that the Somalis understood what they signed. They just signed the agreement that we gave them. And actually similar comments have been made on many occasions by capital exporting negotiators with respect to the BITs that they have concluded with developing countries and LDCs. But things have improved since then, and I think that the situation is changing. The situation is changing because developing countries and LDCs have become aware of the implications that the standards, fair and equitable treatment, an umbrella clause, a full security and protection, the most favored nation clause. You know, when you are not acquainted with the actual implications and interpretations and the scope of those standards, you take them at face value. And you say fair and equitable treatment. Of course, we will treat fairly and equitably all those who come to us. But you don't know that some arbitral tribunals have interpreted fair and equal treatment as being tantamount to a stabilization clause. You are not aware of that. So you will say, what's wrong with signing on to a fair and equitable treatment clause without being aware of the possible interpretations that may be given to it? And that is why it is to be welcomed that certain regional integration groupings, particularly in Africa, have actually come up with model bilateral investment treaties. If we take, for example, the SADC, the Southern African Development Community, it has now a model BIT. As you know, SADC has 15 member states, and 8 of them are actually LDCs. And the SADC model BIT emphasizes that the purpose of investment promotion is to support the sustainable development of the host state by highlighting the obligations of investors as well as of host states. So unlike many of the model BITs of developed states, the SADC model BIT imposes obligations on investors to provide information about their investment to the host state, to conduct environmental and social impact assessments, to comply with minimum standards for human rights, the environment and labor, and to act in a transparent manner with regard to investments involving the government. A second type of agreement that has also been elaborated by developing countries is the Camisa investment agreement, the common market for Eastern and Southern Africa, which was adopted already in 2007. And the Camisa, as a regional grouping, comprises 19 member states, 12 of which are LDCs. Of course, the membership of Camisa and SADC overlap to a certain extent, as the name indicates also. But like the SADC model BIT, the Camisa investment agreement recognizes the non-economic implications of FDI for the host country and emphasizes in particular the importance of environmental and labor protection in the host country. Unfortunately, these instruments have not yet been put to much use, but we hope that they will be used in the near future by those states. In fact, despite the fact that the Camisa agreement was adopted 10 years ago, it has not yet reached the required number of ratifications to enter into force. And South Africa, which of course is not an LDC, is the only country that has been trying to use the SADC model BIT. But the capital exporting countries themselves are now becoming aware, because you cannot just be a pure capital exporting country. You are also a capital importing country. And it is quite easy that the chicken may come home to roost, and that you may actually be taken also before an arbitral tribunal to settle your disputes with foreign investors. And so they are modifying their BITs, and they are also becoming more conscious and more aware of standards for the protection of the environment, labor, and human rights, and have been including such standards in their own BITs, which are concluded with developing countries. And for example, in the case of Canada, which concluded BITs comprising clauses on environmental and labor protection, it concluded the first BIT of that kind with Benin in Africa, which is a least developed country. And since then, it has concluded with a number of other LDCs. A second major challenge facing LDCs concerns the nature of the standards themselves, as I have just said. They are all standards that have emerged from the practice of the capital exporting countries, and they have been elaborated, studied, and reflected on by experts in those countries. So for the representatives of LDCs, the meaning of those standards is often opaque and less well known. Jeremy Bentham, a British philosopher, observed already in the 18th century that law is sometimes like a thick mist, he said, through which not even a man of sense and learning who is not in the trade can see neither through nor into it. Those standards are exactly what Jeremy Bentham described. Unless you are in the trade, they are a mist, through which it is difficult, even if you are full of sense and wisdom, to see through them. So LDCs will need a lot of people who are in that trade and who are trained in investment law in order to be able to understand the standards to which they are subscribing. Let me move to another set of challenges, which is intimately linked to this, and this is the challenges in relation to arbitration. And I have spoken in many forums about this, about the arbitration and the challenges that arbitration poses and presents to developing countries as a whole. But I will only say a few words about it today. It is invariably included in all BITs, unless, of course, the country says, no, we will not have a dispute settlement which refers to arbitration outside my country. I say outside because, as we all know, very few arbitral tribunals, the venue of very few arbitral tribunals is in developing countries. Let us forget about LDCs, and that is what I usually refer to as delocalization of arbitration, because developing countries have to travel a long distance in order to appear before arbitral tribunals. They are not usually held in Africa, Asia, or not even in Latin America. So before coming to the interpretation of the treaty standards themselves, the main challenge faced by LDCs concerns actually the composition of the arbitral tribunal as such. The composition of a tribunal is of unique significance because the awards that they issue contribute to the development of investment law through the incremental concretization of treaty standards. It is the arbitral tribunals which interpret the standards that I say are like a thick mist through which it's difficult to see. So most of the time, LDCs do not have the experienced arbitrators, and the type of arbitrators that they appoint are not their nationals. As a result, LDC perspectives are not brought to bear on the decision-making process in arbitral tribunals. The concerns of LDCs are relegated to the sidelines and are not usually reflected in the interpretation of investment treaty standards. Although the arbitration is about the conduct of their authorities, their policies, or their legislation. So it is extremely important that LDCs should appoint arbitrators from LDC countries to such arbitral tribunals, because otherwise their perspectives and their concerns will never be reflected in the interpretation of the law, and the law keeps evolving, the law keeps developing, and it can only develop through interpretation of tribunals. Then there is the issue of the standards, of the interpretation of the standards, as I have already mentioned it. Of course, certain standards are interpreted in a broad manner, which was totally unexpected by the developing countries, or the LDCs that have subscribed to those standards. And this is a consequence of the BITs. And one official from Malaysia said, and I quote, "We learned our lesson with the arbitration cases. The treaties need to be balanced. So we are also tightening up our provisions, just like the Americans," he said, "and we are limiting the role of arbitrationists, making sure they don't run wild with favoring investors." That's extremely important for the developing countries, for the LDCs, to make sure that arbitral awards are balanced. And of course, that balancing can result from the standards that are included also in the BITs. This leads me to my final point. Can the challenges that LDCs face be best met through expert advice or through the development of skills by training initiatives? The program that is being launched here today is of great importance to the LDCs because it will offer advice to their authorities on the points which I have just raised and the challenges facing them with respect to the negotiation, to the conclusion of BITs, to the type of standards that should be included in such BITs, and of course could also advise them on participation in arbitral tribunals. But in my view, that is not enough. What the LDCs need most is capacity building. So there has to be a very important component of this program which is devoted to training of the local people in the LDC countries. So in order to avoid the perpetuation of reliance on foreign expertise, it is desirable to have, in the short term, of course, assistance and advisory services, but such advisory services should be linked to training programs to ensure that there is a good pool of domestic talent that can help LDCs face the challenges that I have outlined this morning. There is an African proverb which says, if you borrow another person's legs, they will not get you very far. Of course, it is a little bit abstract, but it is true. You can borrow advisory services for a while, and they are important, but you cannot rely on them forever. So there is IDLO, which where I actually used it to teach when it was IDLI, and which has, for the past 30 years, been training lawyers from the developing countries in international economic law, international trade law, investment law, transfer of technology, etc. And IDLO can contribute to this type of training. And there is the African Institute of International Law, which was created a few years ago and which is based in Arusha, Tanzania. And the African Institute has actually been training African lawyers in BITs and arbitration. It has already trained more than 150 practitioners and government officials in the area of BITs. And it will continue doing so because it is in partnership. It does this in partnership with the African Legal Support Facility of the African Development Bank. So I think the main emphasis should therefore be placed on extending and strengthening the training programs of the African Institute of International Law and IDLO in favor of LDCs, their officials, practitioners, and scholars, so that they have very well-trained investment lawyers who can negotiate for them. That is the best way for LDCs to meet the challenges, to negotiate in an informed manner, to conclude better BITs, and to participate effectively in arbitrations affecting their particular interests and circumstances. They will have to develop their own legs in order, instead of borrowing the legs of others. Thank you.
Many thanks, Judge Yusuf, for the lucid and compelling analysis of the challenges that the LDC face, and you also raised the importance issue of capacity building and training, and that is a second phase of a different project that we are looking into.